पहले तो ये बड़ी खुशकिस्मती सी बात है, इनका टाइम कीमती है, तो मैं दावत देता हूँ जस्टिस मियांगुल हसन औरंगजेब साहब को कि वो आएँ और अपने ख्यालात का इज़हार करें। थैंक यू।
Assalamu alaikum. Thank you very much, Lawrence Saab, Qazi Saab, for that introduction which I do not deserve. But I am very happy to be amongst all of you. It's going to be the advent of a new chapter in your lives. And I wish you all the best. And to forewarn you that the life of a legal practitioner is a tough life. And you all should be prepared to put many, many hours of hard work. And this tough life is going to be through your career as a practitioner. Because the legal profession and the law is like an ocean which knows no bounds. So even lawyers with many, many years of experience, with decades of experience that I have witnessed, are still learning. If you are a student of law, I assure you that you will always remain students of law. I am still a student of law, and I learn every day new areas and new vistas in this beautiful field. You are now out of the category of what is known as a layman. You people are not laymen. You people are now men of letters. Once you obtain your licenses and once you obtain your degrees, you will get the title of learned with you. And you will conduct yourself in every walk of life, whether in the court or outside the court, like learned people. You will behave like learned people, and you will conduct yourself so as to become examples for others. Going out of the general issues and going into a specific area, you are all now prepared to go to the court. But there is a mechanism in the law where parties are encouraged to settle their disputes out of court. Long, time-consuming and delaying court procedures led to an alternative system for resolution of disputes to be developed. It comes in different forms. One form is called arbitration. The other form is called mediation. Another is called conciliation. And yet another is called third-party expert evaluation. All these subjects are aimed at settling disputes. Courts are also established to settle disputes. But with this alternative system for the resolution of disputes, the advantage is that it is in a more relaxed environment. Norms of propriety do apply to it, but you, when in a dispute with another party, which prefers to have the disputes resolved through arbitration, you will have the liberty to appoint your own judge. And that judge is known as an arbitrator. He determines the facts and the law. He will follow a procedure that he will set for himself. Unlike what you have read in the Code of Civil Procedure, that there is to be a suit, it is to be drafted in a certain manner. There has to be an introduction of the parties. You have to set out what your claim is. You have to write what the cause of action is. You have to write the evaluation, etc., and then how to make a prayer. In arbitration, it is not so formal. You have to make a statement of claim because you have to explain to the arbitrator what you want and the basis on which you want it. There is no written statement, but its equivalent is known as a statement of defense, because the other side has to condescend to the particulars. It has to either admit or deny. The arbitrator does not have to follow the procedure of framing of issues and recording of evidence, but if he feels the need to do so, there is no bar on him doing that. And once he hears the parties and he understands what the dispute is, he gives a judgment. And that judgment in the field of arbitration is known as an award. Now, when in arbitration proceedings an award is rendered, is it equivalent to a judgment? Can you tell the other party to make payment in accordance with it? There is nothing stopping the parties to accept it. Both parties may comply with it. But where you feel that an arbitrator has given an award and you need to enforce it through the process of the court, the Arbitration Act provides for a mechanism where you will file it in the court and request the court whether the award, the judgment that the arbitrator writes, does it have validity. While the arbitrator was conducting arbitration proceedings, did he misconduct himself? There is a very limited manner in which the court has to examine the award. The court does not sit as a court of appeal to reopen the entire case, but examines the case in a very limited way. And if it comes to the conclusion that there is no invalidity and the arbitrator has not misconducted himself, he will make the award a rule of court, which means that he will pass a judgment and decree in terms of the award. And once you have that in your hand, it is executable and enforceable like any other judgment from a court. So this is how the arbitration process culminates into a decree which is enforceable. So you have a judgment in your hand. Naturally, there are rights of appeal which are provided in this law. But I must tell you that our law of arbitration is now very old. It was made in 1940. It is a consolidated act. Why is it consolidated? Because before 1940, there was an Arbitration Act of 1898. But it dealt with a limited scope of arbitration without the intervention of the court. And the rest of the law of arbitration was contained in the CPC. Arbitration was all provided in the Code of Civil Procedure. In 1940, the provisions in the CPC regarding arbitration were repealed. And so was the Arbitration Act of 1898. And a consolidated 1940 Act was made. Now, the 1940 Act provides for 3 modes of arbitration. 3 modes. But before any of these modes are invoked for the arbitration to start, what is most important is for there to be an arbitration agreement between the parties. And that agreement has to be in writing. It can't be oral, it has to be in writing. The law requires that. It can be a self-contained arbitration agreement, where the entire agreement only deals with arbitration, or it can be a clause in a wider contract, in the sense that, say for example, there is a construction contract. The construction contract provides for the rights and obligations of the parties. It will also include a clause for arbitration. There may be a contract for the supply of goods. It will deal with the rights and obligations, but will also contain an arbitration clause. So there has to be an agreement in writing between the parties to arbitrate. Now, when a dispute arises and a party wants to start arbitration, what will he do? And what are his options? The first option is that he will opt for arbitration without the intervention of the court. He will not go to the court. The Arbitration Act 1940 provides for a mechanism. He will send a notice to the other side that here is a dispute between us, we want to resolve it by arbitration. Please agree to the appointment of an arbitrator. Assuming the other side agrees, an arbitrator is then appointed and he will start the proceedings. And he, as I said earlier, regulates his own proceedings. There is a different mechanism for sending notices to start arbitration. It depends on whether the agreement provides for one arbitrator or more than one arbitrator. Whether it provides for an even number of arbitrators, meaning 2 or 4, or an odd number, 1, 3, 5. If it provides for a 2-member arbitral tribunal, one of the parties will appoint its own arbitrator, send a notice to the other side, I have appointed Mr. X as my arbitrator, now you please appoint your arbitrator within 2 weeks. If within 2 clear weeks of that notice, he does not appoint his own arbitrator, then the Mr. X who was appointed becomes a sole arbitrator. So even though the agreement provides for 2 arbitrators, the behavior of the other party, which does not want the arbitration to proceed further, will result in the arbitration being conducted by one arbitrator. There's another provision in the Arbitration Act which deals with the situation where the contract provides for a single arbitrator. There you will write a notice to the other party saying, let us agree on an arbitrator. The other party may agree. So there will be an arbitrator appointed by consent. But because there are disputes going on between the parties, they may not agree. What do you do in this situation? There the law says that you can go to the court, file an application under Section 8 of the Arbitration Act and say, look sir, I gave him a notice to appoint an arbitrator by consent. He's not doing it. Please appoint an arbitrator for me. And the court will appoint an arbitrator, so that the machinery and the mechanism for the arbitration continues and does not come to a halt. This is known as arbitration without the intervention of the court. There is a chapter 2 in the Arbitration Act. It deals with arbitration with the intervention of the court. And this is something that you as practitioners will be dealing with a lot. Do bear in mind that now we are living in a commercial world, and you will hardly find any contract that does not contain an arbitration clause. And these disputes are to be resolved in accordance with this mechanism. So when you opt for arbitration with the intervention of the court, you will see that Section 20 of the Arbitration Act provides for it. And there are some conditions that you have to meet. In your application under Section 20, you have to first of all plead the contract that exists between the parties and perhaps refer to the arbitration clause in the contract between the parties. Number 2, you have to list the disputes. There may be only one dispute, there may be more than one, there may be several disputes, But all those disputes must be categorized so that the court knows that these disputes arise from this contract. They arise from this contractual relationship. They are covered by this contract. And the reason why the listing of these disputes is very important is because the court will have to refer these very disputes to the arbitrator. So you must not leave your application under section 20 vague. You will have to say that under this particular clause, this was my claim and it is denied by the other side. This is dispute number 1, 2, 3, 4, and so on and so forth. You must also plead that the arbitration agreement was executed within the jurisdiction of the court to which you make that application. You will determine the jurisdiction of the court by reference to section 20 of the Code of Civil Procedure. If the cause of action is accrued over there, if the respondent in that application resides within the territorial jurisdiction of the court, and whether the agreement was executed or even performed in the jurisdiction of that court. And then obviously you will have to see that that court does have the pecuniary jurisdiction to deal with the matter. Once this is done, the other side is issued notice by the court. Now, the law requires that the other side has to show cause as to why the matter should not be referred to arbitration. Unfortunately, in practice, what the court does is that it calls upon the other party to file a reply. This is a mistake. The notice should be a show cause notice. It should be self-executed. That in the sense that if the party does not respond within a certain time, the reference should be made. Because the foundation of arbitration is that it is a time-saving device. It is an expense-saving device. So the court must be conscious that all the steps with respect to arbitration have to take place as quickly as possible. Long delays should be avoided. The other side may come up with a reply and convince the court that there is no dispute between the parties. What is a dispute? A dispute is an assertion of a right by one party and its denial by the other. That has to be seen from either the correspondence or the file. It may come with an objection saying that there is no jurisdiction or there does not exist an arbitration agreement between the parties. But when the matter is referred to arbitration, the court normally fixes a period of 4 months for the arbitrator to decide the case and to render the award by filing it in the court. When arbitration is with the intervention of the court by filing a section 20 application, the arbitrator is supposed to file the award in the court. Why 4 months? That's because it is referred to in the schedule to the arbitration. In practice, it may take much more than 4 months because some of the disputes are very complex. The arbitrator may set a schedule in which it may become ripe for the recording of evidence in 4 months. So, at the time when the Act was enacted, the 1940 Act in 1940, the disputes that we see now of a commercial nature, of a complex nature, and which are so heavy and so voluminous, were perhaps not envisaged. So, the 4-month period is to be treated as directory. And then, when the award is rendered, the process that I spoke to you of earlier, that follows and the award is made a rule of court. The third option available to a party, or the manner in which the matter is referred to arbitration, is in a pending suit. The parties may be in litigation with each other. There may be a suit, like for a declaration, for specific performance. During the pendency of the suit, both parties may agree to refer the matter to arbitration. That is provided in section 21 of the arbitration. So a joint application can go and the parties can seek a reference to arbitration, and then the same process follows. I don't want to delve very deeply into the processes under the Arbitration Act 1940, because this may not be the law in Pakistan for very long. There have been proposals with the Law Commission of Pakistan to amend this law. The provisions in the Arbitration Act have been subjected to so many conflicting interpretations, which has made the process of arbitration very cumbersome, extremely cumbersome. So therefore, there is a bill on the Arbitration Act for Pakistan, and it is based on the UNCITRAL model, the United Nations International Trade Law. It is adopted in 90 countries, more than 90 countries across the world. In India, it was adopted in 1996. But in Pakistan, we may have this law as early as this year. And this will be a law which will cater for domestic arbitration, and a part of it also caters for the international arbitration. For the international arbitration, we presently have an act known as the Arbitration and Conciliation Act of 2011. There are situations where commercial parties in Pakistan may deal with parties from foreign countries. The parties from a foreign country may not be happy with the manner in which disputes are decided in Pakistan, or may not even opt for arbitration under the Pakistani law. They may want the arbitration to be governed under some international conventional rules, like for example the ICC rules or the LCIA rules. They provide for a mechanism for this international arbitration to take place. They are more speedy and they result in an award. Now, in an international scenario, say for example, there is an award rendered in, for example, London. What do you do with that award? Can you enforce it in Pakistan? Can you bring it and treat it like a judgment or a decree? Under the 2011 Act, you have to bring it to Pakistan, not go to the civil court, but go to the High Court, which has been given exclusive jurisdiction in the matter, in order for it to be enforced. So the enforcement procedure takes place directly through the High Court. But the other side has the option to file objections to the award, the party against whom enforcement is to take place. And just like under Section 30 of the Arbitration Act 1940, the grounds on which you can challenge the award is very limited. Same is the case with international arbitration. It is based on the New York Convention of 1958, which was made a part of the domestic law of Pakistan in 2005 through an ordinance which was re-promulgated from time to time until 2011, when it was given the status of an act. The entire New York Convention on the enforcement of foreign arbitral awards, recognition and enforcement of foreign arbitral awards, is a part of the schedule to the 2011 Act. And this is the first statute that I have come across in which the schedule of the Act has been given prominence over the substantive provisions of the Act. In an event of a conflict, it is the terms of the schedule that prevail. Now that schedule contains an Article 5. And Article 5 are the very, very limited grounds on which you can raise objections to the enforcement of the award. There are now many judgments emanating from the Sindh High Court, from the Islamabad High Court, from the Lahore High Court, where such awards rendered in foreign countries have been brought to Pakistan and enforced in Pakistan. They are being enforced in Pakistan. And there are two judgments of the Honorable Supreme Court where they have upheld such enforcements. I think that's quite a bit as far as arbitration. Let's now move on to the other concept of alternative dispute resolution, which is mediation. What happens in mediation? Is there a third party that decides the disputes? Does he take evidence? Does he give a judgment? Does it have to be made a rule of court? How do you start it? We have the Alternative Dispute Resolution Act of 2017 for Islamabad. There is no better way of resolving disputes other than in a manner to do it consensually. There is no better thing than an amicable settlement of the disputes. And it must be encouraged at every level. Before going to the court, before incurring the expense, before going through the rigors of the trial, you must try and resolve the dispute inter se between the parties for your own sake, to save your time, to save your expense. And therefore, before going to the court, both parties can agree to have their disputes resolved through mediation. The foundation of mediation is consent. Both parties have to agree. And both parties have to agree on a mediator to be appointed. Under the 2017 Act, a mediator is known as a neutral because he is supposed to be neutral between the parties. He does not represent one party against the other. He is impartial. And the mediation that is conducted before him is totally confidential in nature. He tries to bring the parties to the negotiating table. He will understand their dispute. He cannot advise the parties. He cannot tell a party that you are right and you are wrong. He will try to understand the perspective of both the parties so that there is a meeting of the minds and there is a give and take by either of the parties. In a suit, in a claim, we exaggerate. As practitioners also, if there is a certain claim that we want, we would ask for something many times more. This is what is known as our position. This is what is known as our position. This is the position that we adopt. But what is our interest? What is it that we actually want? What is it that we actually desire? It is a certain amount which you actually feel that the other party has wrong. It is the mediator's job to understand from interviews with the parties to determine what that amount is. And not to coerce, not to convince a party to enter into a settlement, but to answer his questions and to pose questions by saying that, have you been advised that if you take this position to the court, will you win? There is something which is known in the mediation parlance as BATNA. BATNA is your best alternative to a negotiated settlement. What is your best alternative to a negotiated settlement? Going to the court, paying a lawyer, dates of hearings day in and day out. When will the conclusion come? So if this is your best alternative, why don't you have a bit of a give and take and obtain what your interest is as differentiated from your position? And once the parties understand each other's positions and they come to a settlement, it is successful mediator. And what the mediator is supposed to do is reduce that settlement agreement into writing. The parties will file it, sign it, and he will sign it. And then he will produce it before the court, for the court to give it the status of a decree. It will have a status of a consent decree. Now the reason why a decree is required is for enforcement purposes. A party may agree today, but he may resign from it tomorrow. But when his settlement agreement as a result of mediation is reduced into writing, he will be stopped from going against the decree that is rendered. Now, before rendering a decree, the court is not supposed to invite objections. The court is only to convince itself to see as to whether has there been an actual settlement. And both parties come and they say, yes sir, these are our signatures and this is what we agreed. And it is only after carrying out this exercise will he give it a stamp of validity by making it into what is known as a rule of the court, which is then subsequently enforced. There may be parties who during the arbitration will stick to their position in such a way that they are being unreasonable. They actually thwart the arbitration proceedings. They derail them. You must have heard of this word, unscrupulous litigant. They are unscrupulous in their behavior. They want to bother the other side. And if by reason of this behavior the mediation fails, the mediator is supposed to report it. That the mediation could not take place because of this event. That is especially if the matter is referred to mediation by the court. We encourage it, at least in the Islamabad High Court. When a judge of the district judiciary decides a contested case, he is awarded with certain points. And those points go down well as far as annual confidential reports are concerned. It shows, the level of his performance. We have now taken a decision that any party, any judge that refers a matter to mediation and it results in a successful mediation, he is going to be awarded the points of a contested case, so that this process is encouraged. Now, the reason why the conduct of a party is important in mediation is we also have in Islamabad the Cost of Litigation Act of 1970. There is a concept of costs, which is that the costs follow the event. The costs follow the event. What is meant by that is that the loser pays for the winner's costs. It is mandatory under the law to make the loser pay for the winner's costs unless the loser comes up with a very plausible defense and an arguable case where it may be in the discretion of the court not to award. But in mediation, where a party unreasonably withholds its consent to mediation and finally loses the case, because if, say for example, the mediation fails, there is an effort to make a settlement between the parties. And there's no harm because the courts are there. They will decide the dispute for you. But if the party who unreasonably withholds his consent to mediation ultimately fails, and there is a cost award, the court has to be conscious that it is because of him that my time was wasted. So punitive costs can be engaged. This is a subject where we can go on and on for hours and hours. But I hope that in the future we get an opportunity to interact further on this subject and other subjects. You are entering into the most coveted, the most sought after profession. This country was created by a lawyer. And all of you, in your own individual capacities, will contribute to the life and liberty of this country. Thank you so much.
Any question from any side? Question करना चाहेंगे?
So I have two questions. First is regarding what is the regulatory body in Pakistan for arbitrators itself? Because I do have come across certain arbitrators who do not have that much legal background, but they still are appointed as arbitrators. One. And second, you mentioned that we can refer to the international boards. Does it refer as a persuasive authority or a binding authority of the board?
I'll answer your second question first. the awards that are rendered in foreign countries will perhaps help an arbitrator in following those awards in deciding an individual dispute. Like say for example, under the construction law, if there is a dispute regarding the bills of quantities and it's been resolved in a certain way through an international arbitration, that may help you. It's most definitely not binding. Judgments rendered by courts of different countries again have a persuasive value in Pakistan. The New York Convention that I spoke of 1958, has been ratified by more than 100 countries. And they have domestic laws recognizing this convention. I had the privilege last year of giving a judgment on the enforcement of a foreign arbitral award in Islamabad. It was a dispute between a Chinese construction contract company and the National Highway Authority. The award was rendered in Paris and it was brought to Pakistan for enforcement purposes, and many objections for its enforcement were raised. Now, because the New York Convention is the New York Convention which is applicable everywhere else across the globe. So the judgments that were rendered by different foreign countries or courts in different foreign countries were of a help to me in deciding the case before me. But you would see when you read that judgment, it's reported in last year's CLDs, the corporate law decisions. The name of the case is National Highway Authority, China Water Construction Company versus National Highway Authority. There was a question as to whether an interim award can be enforced or not. And the Supreme Court of Queensland had taken a certain decision about the fact that it cannot be enforced because it is not final. I did not agree with it. I came to a different conclusion. So this is to answer your question that these judgments are not binding on us. We understand them. They help us in giving us an understanding about the convention and about the dispute. If they convince us, we will follow them because they are of most definitely not of a binding nature. But if they do not appeal to us, then we will take a contrary view. And in this case, I took a contrary view from the Supreme Court of Queensland. I've forgotten your first question.
Yeah, the regulatory body.
This is also a very good question. The reason why there has to be a regulatory body is because there has to be standardization of arbitration. There has to be a standardization. What I mean by that is that, say for example, there is a certain institute, like there is the International Court of Arbitration in Paris, the London International Court of Arbitration, LCIA. They have their own secretariat and they have their own rules for arbitration, separate rules. They have with them in their panel hundreds of arbitrators accredited with them. And the secretariat knows the expertise of those arbitrators in the fields of law, which are different in nature. There may be a dispute with international trade, there may be a dispute concerning land, there may be disputes concerning trusts, there may be disputes concerning insurance. And because we are living in an era of specialization, so you want an arbitrator who's a specialist in the matter, who's well versed in the sort of a dispute that you have, to refer the matter to them. In Pakistan, also in Karachi, there was an effort to make such a body. We have the ICC in Karachi. It is linked with foreign bodies also. But it is not functioning in as robust a manner as it should. And Pakistan is a ripe country for such an institution to be made. Like say for example, for mediation. There are mediation centers There are 4 or 5 mediation centers, sir, correct me if I'm wrong, in Islamabad already. So there, the mediation centers have mediators on their panel. Like Qazi Saab is an accredited mediator. And let me boast about myself that I am an accredited mediator. I got my result just last week. So, because a third party which is appointed as a mediator, who's not a trained mediator, can perhaps not have the skills to bring about a dispute. But Pakistan is a ripe country for such an institute like the ICC, like the LCIA, to be established in Pakistan, so that, and then that body can be an oversight body. Here what happens is that the arbitrator is appointed by the court. And the court will examine his conduct when it is looking at the award. There is a provision in the Arbitration Act that if, say for example, you've referred a matter to the arbitration and the arbitrator is too slow, he doesn't call the parties, he's too preoccupied, there is a mechanism that you can go to the court by filing an application under Section 5 and Section 11 of the arbitration saying, please remove him. I want another arbitrator to be appointed. So the regulatory mechanism of this nature is there, but for there to be an oversight body on arbitrators in Pakistan, that unfortunately we do not have. जी. जी.
वो क्वेश्चन है, सबसे पहले एक वर्ड यूज किया आपने कि 2017 एक्ट के मुताबिक न्यूट्रल पर्सन को अपॉइंट किया।
जी.
उस न्यूट्रल पर्सन की न्यूट्रलिटी को कोई रेगुलेट कर रहा है या नहीं कर रहा है, और अगर कोई रेगुलेट कर रहा है तो उसके बाद न्यूट्रल मीडिएटर को कोई अप्लाई कर रहा है उस सूरत में कि व्हाट इज दिस टेक्निकली। और सेकंड क्वेश्चन भी मीडिएशन से है कि अगर अभी जिस तरह कंसेंट फॉर्म साइन होता है जब हम फाइल करते हैं तो उस पर 95% अबाउट यही है कि मीडिएशन पे कोई नहीं जा रहा है डायरेक्टली, वो कह रहे हैं कि कोर्ट में बेहतर इसको कर सकते हैं। लेकिन कुछ डिस्प्यूट्स पे कि जिससे मतलब ये सजेशन भी हो सकती है कि कोर्ट्स या जो ये रूल्स बना रहे हैं इस लिहाज से तो वो दे सकते हैं, लाइक रिकवरी की डिस्प्यूट बैंक रूल्स वगैरह हो गए और इंश्योरेंस के रिलेटेड हो गए, तो वाई नॉट उसको स्टार्ट किया जाए क्योंकि उसमें तो मेनली अकाउंट्स के साथ भी लायबिलिटीज कनेक्टेड होती है। तो उसको डिटरमिन करने के लिए एग्जांपल इसकी है कि इंडिया में रिसेंटली ओडीआर का सिस्टम किया है कि वो इवन जो कॉस्ट का वो है उसको बहुत ज़्यादा कंटेस्ट कर रहे हैं कि क्या कॉस्ट बचाती है या नहीं, क्योंकि वही कम यूज आना होता है दोबारा सारी चीज़ें करने के लिए यूज़ ऑफ टेक्नोलॉजी का बहुत ईजी है। अगर क्या ये मीडिएटर टेक्नोलॉजी से कि उसको यूज़ करके उनको आने की ज़रूरत ना पड़े तो केवल ही सॉल्व हो जाए और कॉस्ट इफेक्टिव कर दो
जो पहला सवाल आपने किया कि मीडिएटर्स के लिए कोई रेगुलेटरी बॉडी टू ओवरसी द, जो 1917 का एक्ट है उसमें पार्टीज को भी इख्तियार है कि वो किसी भी आदमी को अपना मीडिएटर अपॉइंट कर सकते हैं, लेकिन फेडरल गवर्नमेंट को इख्तियार दिया गया है कि वो नोटिफाई करेगी मीडिएटर्स को, वो अक्रेडिटेड नोटिफाइड मीडिएटर्स होंगे। वो कौन लोग होंगे? क्या आप सिंपली उनको अप्लाई करेंगे कि जी मेरे पास लॉ डिग्री है, मेरी ये एक्सपीरियंस है, मुझे आप मीडिएटर बना दें? नो, आपने मीडिएशन का एक कोर्स करना होता है, ठीक है। वो डिफरेंट इंटरनेशनल इदारे हैं, पाकिस्तान में अभी तक एक ही है, लाहौर में एक ही इदारा है, वो ट्रेनिंग करता है, लेकिन ये डोनर्स पाकिस्तान में आते हैं और अभी रिसेंटली हमने फेडरल जुडिशल एकेडमी में ये ट्रेनिंग की है। 40 घंटे की ट्रेनिंग होनी होती है। उस ट्रेनिंग के बाद बाकायदा एक एग्जाम होता है, इट्स ए 3 आवर पेपर, जिसमें आप मल्टीपल चॉइस क्वेश्चंस होते हैं, आपको सिनारियोज देते हैं कि इस सूरत हाल में मीडिएटर को क्या इकदाम उठाने चाहिए, और उसके बाद एक मॉक मीडिएशन भी होती है जिसमें 2 पार्टीज होती हैं और उनको कहा जाता है कि उन्होंने आपकी زندگی کو مشکل بنانا ہے، مطلب کہ آپ اپنے ساتھ ڈسپیوٹس جو ہیں وہ سختی سے اپوز کر رہے ہیں. تو اس میں دیکھا جاتا ہے کہ اس ٹریننگ میں آپ نے کیا سیکھا، ان پارٹیز کے ساتھ کس طرح آپ کنڈکٹ کریں گے. یعنی آپ کو وہ سکھاتے ہیں کہ دونوں پارٹیز کو آپ نے کمفرٹیبل بنانا ہے تاکہ وہ آپ میں ٹرسٹ ریپوز کریں، تاکہ وہ آپ کے ساتھ کھل کے بات کریں. اگر وہ آپس میں آرگیومنٹس کرنے لگ جائیں، بحث کرنے لگ جائیں، تو آپ نے ان کو کس طریقے سے روکنا ہے. اور اگر آپ سمجھتے ہیں کہ دونوں ایک کمرے میں بیٹھ کے یہ ڈسپیوٹ ریزالو نہیں ہو سکے گا، تو آپ پھر پرائیویٹ سیشنز کرتے ہیں. اس پرائیویٹ سیشن میں آپ نے کیا کیا باتیں بولنی ہیں ایک پارٹی کو، تاکہ وہ آپ کو وہ ساری باتیں ڈسکلوز کر دے، تاکہ آپ اس کا کیس سمجھ آئیں کہ جی اس آدمی کا انٹرسٹ کیا ہے. پوزیشن کچھ اور ہے، انٹرسٹ کیا ہے، یہ آدمی کس صورتحال میں اپنے مسئلے کا حل چاہے گا. ٹھیک ہے نا. تو جب ایک میڈیٹر یہ ٹریننگ کر لیتا ہے اور پاس کر لیتا ہے، اس کو پھر ایکریڈیٹڈ میڈیٹر کا درجہ دیا جاتا ہے، اور ہماری منسٹری آف لا اس کو باقاعدہ ایک نوٹیفیکیشن کے تھرو نوٹیفائی کرتی ہے. ٹھیک ہے. تو یہ نہیں ہے کہ ایک میڈیٹر ہے وہ اس کو مطلب ٹھیک ہے ایکسپیرینس والا آدمی ہے، وہ شاید پارٹی کو ایڈوائز کرے کہ جی میرا مشورہ یہ ہے کہ آپ یہ آپ نہیں کر سکتے. وہ شاید پارٹی کو کہے کہ اوہ تمہارا تو کوئی کیس ہی نہیں بنتا. یہ باتیں میڈیٹر نہیں کر سکتے. تو یہ اس ٹریننگ میں اس میڈیٹر کو بتانا پڑتا ہے، اور وہ ایگزام کافی خاصا مشکل ہوتا ہے اس کو پاس کرنا. اور اگر سے فار ایگزامپل ایک میڈیٹر اپنے آپ کو مس کنڈکٹ کرتا ہے اور اس میں پارشیلٹی دکھاتا ہے، تو 2017 ایکٹ جب آپ پڑھیں گے تو اس میں ایک رپورٹنگ میکنزم ہے، اور پھر منسٹری آف لا اس کا نام اس لسٹ سے نکال سکتی ہے. پیونیٹیو میجر بھی اس میں ہو سکتا ہے. یہ جو سیکنڈ آپ کا سوال تھا، چونکہ ابھی اس میڈیشن کو حکومت بھی انکریج کر رہی ہے، the government is also encouraging. تو ابھی آپ دیکھیں گے کہ ہمارے جو پبلک سیکٹر آرگنائزیشن ہیں، ٹھیک ہے نا جی، جس طرح پہلے ہم نے نیشنل ہائی وے اتھارٹی کی بات کی، یہ ZTBL، OGDC ایکسیٹرا ایکسیٹرا، جو بڑے بڑے پبلک سیکٹر آرگنائزیشن ہیں، PIA، اس میں انکریج کیا جا رہا ہے کہ آپ اپنے میڈیشن سینٹرز بنائیں. ٹھیک ہے. ہمارے لیے اسلام آباد ہائی کورٹ میں کہنا کہ جی آپ میڈیشن کو انکریج کریں، وہ کہنا آسان ہے، لیکن ہم نے اس کے لیے ایک میکنزم بنانا ہے، اس کے لیے ایک جگہ بنانی ہے، اس لوگوں کو فیسیلیٹیٹ کرنا ہے. تو ہماری جو اسلام آباد ہائی کورٹ کی پرانی بلڈنگ تھی، اس میں باقاعدہ ایک فنڈر نے ہمارے لیے ایک بہت خوبصورت میڈیشن سینٹر بنایا ہے. اور میں نے آج صبح ڈیٹا کلیکٹ کیا ہے ایسٹ، اسلام آباد ایسٹ اور ویسٹ سے. ہماری وہاں پر ماشاءاللہ 100 میڈیشنز چل رہی. تو ٹھیک ہے، پارٹیز کہیں گی کہ نہیں جی میں میڈیشن میں کیوں جاؤں، میں عدالت سے معاملہ حل کرنا چاہتا ہوں، لیکن وہ 100 تو ہیں. اور یہ کانسیپٹ ابھی نیا ہے. ہمارے میڈیٹرز جو ہیں ان کو نوٹیفائی کیے ہوئے ابھی تک 1 سال نہیں ہوا. تو ہم اس بات پہ بہت پر امید ہیں کہ وقت کے ساتھ میڈیشن اسلام آباد میں اور بلکہ پورے پاکستان میں. آپ کو میں ایک اور ایگزامپل دیتا ہوں. یہ ہمیں ایک کورس پہ بھیجا گیا 2022 مئی میں ترکی. ان کا میڈیشن ماڈل اسٹڈی کرنے کے لیے ان کا قانون 2013 میں آیا تھا. ٹھیک جی. انہوں نے ہمیں بتایا کہ 2013 سے لے کے آج تک انہوں نے 3 ملین کیسز ڈیسائیڈ کیے ہیں میڈیشن کے تھرو. ہم حیران ہو گئے، یہ بہت بڑا نمبر ہے. ان کے قانون میں کچھ ایریاز ہیں جہاں پر میڈیشن کمپلسری ہے، ہمارے یہاں کمپلسری نہیں، کنسنٹ بیسڈ ہے. ٹھیک جی. ان کے لیبر لاز میں کمپلسری، تاکہ بیچارہ لیبر جو ہے وہ وکیل اور عدالت اور ان ایکسپنسز میں نہ جائے. اور وہاں پر میڈیٹر کا کچھ گھنٹوں کا خرچہ جو ہے وہ اسٹیٹ پورا کرتی ہے. تو یہ بہت ہی ایک کامیاب کانسیپٹ ہے جو پاکستان میں ابھی گلگت بلتستان میں بہت ایک روبسٹ طریقے سے وہاں کے جو چیف جسٹس ہیں جسٹس علی بیگ صاحب، انہوں نے وہاں پر اس کو شروع کیا ہے, فورن فنڈنگ بھی آئی ہے, اور ایک کانسیپٹ ہے جو شروع ہو گیا ہے اور ابھی شروع ہوا ہے. آپ کو ایک سچی میں بات بتاؤں کہ جو 2017 کا قانون ہے, اس کے پراپر پیرامیٹرز اور اس کی جو امپورٹنس ہے وہ اس قانون بننے کے 5 سال بعد میں نے سمجھی. سو اٹس نیور ٹو لیٹ. اور ہم سمجھتے ہیں کہ وقت کے ساتھ یہ بڑی گورنمنٹ آرگنائزیشنز میں میڈیشن سینٹرز بنائے جائیں تاکہ آدمی پہلے میڈیشن میں جائے, اس کے بعد. ہاں, اب ایک اور یہ اہم چیز اس میں یہ ہے کہ آپ SECP کا قانون دیکھیں اور کچھ اور قوانین دیکھیں تو اس میں یہ کہا گیا ہے کہ آپ کو عدالت جانے سے پہلے ایک میڈیشن کی اٹیمپٹ کرنی ہے. لاہور ہائی کورٹ میں جسٹس جواد حسن صاحب کی ریسنٹلی ایک ججمنٹ آئی ہے, رپورٹ بھی ہو چکی ہے میرے خیال میں PhD میں, ہے جی, پیج 1, ٹھیک ہے نا جی, PhD 2024. تو اس میں سے فار ایگزامپل ایک میکنزم میڈیشن کا ایک قانون میں دیا ہوا ہے. تو عدالت کے پاس جب آپ کیس لے کے جاتے ہیں, ریٹ لے کے جاتے ہیں یا سوٹ لے کے جاتے ہیں, عدالت اس کے اوپر آگے کارروائی نہیں کرے گی اور وہ پارٹیز کو میڈیشن میں بھیج دے. وہ کمپلسری میڈیشن نہیں ہے, وہ صرف اس قانون کی یا اس ریگولیشن کی انفورسمنٹ کر رہی ہے عدالت کہ نو یو سیٹل یور ڈسپیوٹ تھرو میڈیشن. اگر نہیں ہوتا, وہ ایفرٹ انسکسیسفل ہوتا ہے, ہاں اس کے بعد آپ کورٹ آ سکتے ہیں. I hope I've answered your question.
Sir, my question pertains to both arbitration and mediation. So what I want to ask is that once an award is rendered, either in arbitration or mediation, is it necessary that you have to file it with the court, like if the parties agree to execute the award amicably? For example, one party owes a certain amount of money to the other party and they are willing to hand over the cash or bank transfer or whatever without the intervention of the court. So can that be done, or is it necessary that you have to involve the court for execution of the award?
I'll answer this question first in the realm of arbitration, right? You see, once an award is rendered, you will find many judgments which say that an award is a worthless piece of paper unless life is infused into it by making it a rule of court. You will often find this phraseology, that it is a worthless piece of paper unless life is infused into it by making it a rule of court. I don't agree with that, right? The reason why I don't agree with that is because often an arbitration clause provides that the award is going to be final and binding between the parties. So contractually, that award is final and binding between the parties. However, if you want to enforce it, under the law as it stands today, right? Because we have a new Arbitration Act coming in, you have to have a decree in your hand, because it is the decree that is enforced. It is a decree that is enforced, right? So you will have to make it a rule of court by filing an application to the court under sections 14 and 17 of the Arbitration Act.
क्वेश्चन सर ये है कि अगर arbitration proceeding में ही मैटर सेटल हो जाता है कि सब तो वो उसका हिस्सा बन के
उस पे मैं आ रहा था. I was just going to come to that. इसीलिए मैंने कहा कि I don't agree with it. I don't. तो आपने अगर उसको rule of court बनाना है, that is only for enforcement purposes, through the process of the court. ठीक है ना? लेकिन आपको ये judgments मिलेंगी that an award can be used as a defense. An award can be used as a defense. There is a provision in the Arbitration Act where you can obtain an injunction on the basis of the award. आपके हाथ में award आ गया, अभी तक rule of court नहीं बना, आप उस award के basis पे Arbitration Act के तहत injunction ले सकते हैं. But if the award comes and the parties do not dispute it and they act in accordance to it, I think there's nothing like it. और ये ऐसे हुआ भी है. This is more than oh my God, One feels really old because I'm talking about 1998. In 1998, I was appointed as an arbitrator with Raja Mohammad Farooq, Mr. Raja Mohammad Farooq, in a dispute between the World Food Programme and the transporters of food aid to Afghanistan. And we conducted the arbitration proceedings, and we, instead of recording of evidence and framing of issues, went straight into arguments because everything was documented. And the award that was rendered, the parties paid according to it. So that was the end of it. There is no dispute. It is only when you want to enforce something, when you want to force the other party through the process of the court to pay something or to get something or to act in a certain way, when you have to enforce it.
सर ये जो आर्बिट्रेशन का या मीडिएशन का जो प्रोसेस है, इसके अंदर क्या मैनिपुलेशन के चांसेस भी हो सकते हैं? क्योंकि जिस तरह हम कहते हैं कि दिस कंट्री वाज क्रिएटेड बाय अ lawyer, but we have some of the concerns about the ideal implementation of the constitutional law in this country. तो वो जो हमारा जो इस वक्त लॉ चल रहा है, इसमें चूँकि बात स्ट्रेंथ बुनियादें हैं इस पूरे सिस्टम की, जुडिशल सिस्टम की, तो चूँकि जो चीज़ जिस कदर कम्प्लेक्स होती है, जिस कदर कॉम्प्लिकेटेड होती है, उसको डिकन्स्ट्रक्ट करना भी मुश्किल होता है. तो चूँकि मीडिएशन और आर्बिट्रेशन जो हमारा ये चल रहा है जुडिशल प्रोसेस, इससे बनिस्बत आसान और काबिल फ़हम है, तो क्या इसको बाज़ ताकतवर हल्के या कोई भी शख्स इसको मैनिपुलेट तो नहीं कर सकेगा? कोई भी जो ताकतवर.
देखिए जी, आर्बिट्रेटर की सक्सेस क्या है? आर्बिट्रेटर की सक्सेस ये है कि उसका जो अवार्ड है वो दोनों पार्टीज मान लें, ठीक है, जिस तरह इन्होंने कहा. दूसरा उसकी सक्सेस ये है कि उस अवार्ड को रूल ऑफ कोर्ट बना दिया जाए. अदालत उसको मानती है कि ये सही है, और उस ऑर्डर के खिलाफ जो अपील है वो भी डिसमिस हो. तो ये आर्बिट्रेटर के लिए विंडिकेशन है. आर्बिट्रेटर का ये अकेला आर्बिट्रेशन अवार्ड नहीं है, उसने अपने आप को मार्केट में लेके आना है, दैट यस मेरे में ये एबिलिटी है कि मैं इस तरह की जजमेंट दे सकता हूँ, ठीक है. मैनिपुलेशन की जो आपने बात कही, वो अगर आर्बिट्रेटर मैनिपुलेट होता है, एक पार्टी से इन्फ्लुएंस होता है, बायस तरीके से चलता है, तो वो अपने आप को मिसकंडक्ट करता है. ही मिसकंडक्ट्स हिमसेल्फ. अब अगर वो दोहराने आर्बिट्रेशन अपने आप को मिसकंडक्ट करता है, तो पार्टी के पास इख्तियार है कि वो अदालत जाके उसको रिमूव करा सकती है, ठीक है. इसमें अगर आप सेक्शन 5 आर्बिट्रेशन एक्ट का पढ़ें, सेक्शन 11 आर्बिट्रेशन एक्ट का पढ़ें, तो वो अदालत उसको रिमूव करके एक सब्स्टिट्यूट आर्बिट्रेटर अपॉइंट कर सकती है, ठीक है ना. उसके लिए आपको एक प्लॉजिबल ग्राउंड देना पड़ेगा. अदालत को कन्विंस करना पड़ेगा कि इस आदमी ने, इस आर्बिट्रेटर ने अपने आप को या कर रहा है अपने आप को मिसकंडक्ट. अगर वो आर्बिट्रेशन एक अवार्ड में जाके खत्म होती है, ठीक है ना, तो उसमें भी सेक्शन 30 आप पढ़ेंगे, सेक्शन 30 ऑफ द आर्बिट्रेशन एक्ट, तो उसमें भी मिसकंडक्ट एक ग्राउंड है कि उस अवार्ड को आप सेट असाइड करा सकते, उसको आप खत्म कर सकते. तो ये चेक्स एंड बैलेंसेस हैं. और जो मीडिएशन की आपने बात की, उसमें जो कानून है और जो मीडिएशन सेंटर्स हैं, जब आपको एक्रेडिट करते हैं, आपको एक इंटेग्रिटी पैक्ट साइन करना पड़ता है. उसमें आपको अपना एफिडेविट्स और अपना डिक्लेरेशन देना पड़ता है कि आई एम टोटली इम्पार्शियल, ठीक है ना. इसमें मैं आपको एक और बात भी कहना चाहूंगा. कभी कभी इस तरह होता है कि एक आर्बिट्रेटर का नेक्सस होता है एक पार्टी के साथ, ठीक है ना. वो लाजमी नहीं है कि उस नेक्सस की वजह से आप उसको डिस्क्वालीफाई कर दें, लेकिन ये उसके ऊपर लाजिम है कि उसकी डिस्क्लोजर करे, दूसरी पार्टी को बताए कि ये आदमी और मैं कभी एक कंपनी में हमने काम किया है, ये हमारा ताल्लुक है, वगैरह वगैरह. अगर दूसरी पार्टी कहे कि नो दिस इज नॉट एक्सेप्टेबल टू मी, ठीक है, then a substitute can be appointed. But the other party may say कि नहीं, it's okay. अभी like for example जो हुकूमती कॉन्ट्रैक्ट्स होते हैं, उसमें एक प्रोविजन होती है कि अगर say for example नेशनल हाईवे अथॉरिटी का डिस्प्यूट है किसी के साथ, तो उसमें लिखा जाएगा कि जी सेक्रेटरी कम्युनिकेशन जो है वो आर्बिट्रेटर होगा। तो आप कहेंगे कि जी जो NHA है ये तो वैसे भी मिनिस्ट्री ऑफ कम्युनिकेशन के नीचे आता है, तो उसका सरबराह मुझे क्या इंसाफ देगा। लेकिन अगर आपने एक दफा अग्रीमेंट को साइन कर लिया तो फिर प्रिंसिपल्स ऑफ एस्टॉपल अप्लाई होते हैं। फिर आप ये नहीं कह सकते कि ये आदमी बायस होगा। नाउ यू हैव अग्रीड टू दिस पर्सन टू बी। हाँ, अगर उस आदमी का नेक्सस इतना ज्यादा स्ट्रॉन्ग है या जिस कंपनी के साथ आपका डिस्प्यूट है उसी का CEO आर्बिट्रेटर है, तो वहां पर अदालत जो है वो स्टेप इन करके उस आर्बिट्रेटर को रिमूव करके एक इम्पार्शियल आर्बिट्रेटर अपॉइंट करेगी। लेकिन अदालत को आपका कॉन्ट्रैक्ट रीराइट करना वो बहुत ज्यादा मुश्किल होता है। ये इसको you need very strong grounds to convince the court to substitute an arbitrator. Have I answered your question?
Yes.
जी।
So I have a general question.
क्या?
Concerning to the entire judicial system of Pakistan.
अच्छा।
Sir, our judiciary is ranked 129 out of 140. So being part of this judicial system, how do you feel like that, and what reforms and suggestions and recommendations you have to improve the system?
देखिए जी, to begin with, who's doing this rank? You see, अभी recently मैंने तो अखबार में पढ़ा that the Transparency International, everybody is proclaiming themselves to be, the watchdogs of everybody else. So, there has to be a credible data to raise a question mark on the integrity of the judiciary. Having said that, I think every judge is responsible for himself. As long as you have a clear conscience, as long as you have a good night's sleep, because the judicial profession is definitely not financially rewarding, but it is extremely mentally rewarding. You give people your rights,